later. So we'll do this. So Darren, just tell me when you've got it switched over and
yeah, we should be good to go.
All right.
Oh, let me make you the host. Sorry, that's what we do.
Yeah, you have to kind of have to do that.
There we go.
Okay, I'm now the host. So we're going to share that screen and where's my Zoom stuff I want? Oh, here we go. All right. For those of you that I have not had the pleasure of meeting, my name is Kim Hegwood, and I am an elder law estate planning attorney here in Houston, Texas. And so today we're going to talk about what legal documents do you need in place and is it too late? And I'm going to give you lots of little different information about a variety of things as well, because they're all kind of interrelated and I want you to be able to see it. And so we're going to kind of go from there. So a lot of people say, what's elder law versus estate planning? And we always tell people elder law is estate planning on steroids. It's more than just your typical estate planning. It's more than death and distribution. And it's really about taking care of those seniors that are still at home, providing health care for long-term care planning, and then last but not least, if you can't figure out a way to spend all your money while you're alive, then we'll talk to you about leaving some for the kids. So when I tell you documents matter, it truly matters. A lot of people will tell me, hey, I have all my documents. I'm like, great, let me look at them. And while they have documents, they're not what we need. We're going to kind of walk through some different reasons why that a little bit later in the presentation. So if you don't have good documents, it's very difficult to do planning that we need to plan the way we need to plan. And so we want to make sure that people can access, benefits like VA and Medicaid and things like that. And they're really important to have some specific provisions in your documents that allow you to do those types of things, and then maybe we're thinking about how do we take care of, of income and things like that. Because depending on whether or not you need long-term care and you're using Medicaid, we got to make sure that spouse at home is still taken care of. So depending on how your documents are drafted makes all the difference down the road. Those of you that may have children that are disabled, there's a lot of more planning that we want to do. So we want to make sure that if that's an issue, we definitely want to make sure that you see somebody, because it's very specific planning for a child with a disability. In law school, they teach you about, death and distribution. People die, who gets their stuff, but with elder law, we are very focused on disability planning, okay? And so when you talk about disability planning, we're going to hit those 3 important documents everybody needs to have. And so when we talk to you about having a very powerful statutory dual power of attorney, that medical power of attorney, those HIPAA releases, advanced directives, so your medical documents, and then will or a trust, because you're going to need that. And then when you start talking about these things, I'm going to kind of give you a little bit more detail because I think it'll be helpful. And so your financial power of attorney authorizes an agent to make financial decisions. They can handle, bank accounts, they can sell your house, defend you against in litigation. I've done that. I've had to use that. They can make gifts. And for an elder law, in our perspective, in order for us to do a lot of the long-term care planning we need to do, there has to be unlimited gifting. There has to be ability to create trust, because maybe you don't need any kind of facility, living in a facility. So maybe we've got that 5-year look back that is really important, that we can maybe protect some money for that spouse at home. Hugely important. Lots of different things in there that are very important. And I'm going to talk to you at length about the different Medicaid type ones that we put in later in the presentation. Now, your medical power of attorney authorizes someone to make medical decisions for you. They can consent to surgery, they can admit or discharge you from the hospital or the nursing home, and ours are always include that HIPAA authorization inside the medical power of attorney. But if you're not incapacitated, nothing in that medical power of attorney works. So you always do the separate HIPAA authorization, because someone may need to have access to your medical records, maybe to get them from the hospital to the doctor or the assisted living or rehab or however we need to transfer documents and be able to access them when you need them. Your advanced directives have to do with a lot of your end of life decisions, and we want you totally in control of those. We want you to make those hard decisions so your family doesn't have to. And so your directive to physicians talks about if you're terminal and you're going to die in 6 months no matter what, how do you want to be taken care of? Or if you have that irreversible condition, you don't know who you are or anyone else, and you're just there in the nursing home. Do you want to be kept alive like that? For me, I look at this document as quality of life. And in ours, we've gone in and added some extra things in there because one of the things that appears a lot is artificial nutrition and hydration, basically that feeding tube. It comes into play more than you think because if you're in the nursing home and you stop eating, which is a natural progression, of life as things start to decline, they're going to want to put that feeding tube in because they want to keep you longer, but it may not be what you want. If you're in that kind of condition, is that truly what you want? So we want to make sure that you get to express how you want your end of life to be because it's your life and we want it to be the best life you can have. So when you think about, a will, a lot of people understand what a will is. It's a document that says who gets your assets and who's in charge. It only controls what you have in your name, and it must go through probate in order to be effective. So we tell people real estate, oil and gas, mineral rights, and beneficiary designated assets without a beneficiary is the only thing that passes through probate. And if you're single and you use Medicaid for your long-term care, we do not want you to be in probate. So there's lots of things that we want to try to get ahead of time and really work towards to make sure that the plan you have in place is the one that's going to protect you no matter what kind of scenario you have. So do you need a trust? Possibly. Maybe a special needs trust if you have a child or grandchild that has a disability. We do a lot of revocable trust planning, especially if you're on second marriages, his and her kids. It does avoid probate, handles your disability, doesn't protect assets while the two of you are together, but it definitely protects you from disinheriting children. With will-based planning, his and her children, very easy to disinherit children. We don't want you to do that. For those of you that are looking to protect assets, you want to make sure that we can do that with an asset protection trust for those non-retirement assets. Protects you from creditors, predators, divorce, yourself. And if you're looking to protect that spouse at home that may need that money, if you end up in the nursing home, we want to make sure it's there for their benefit because we're all about making sure that everybody has the best quality of life that we can help you achieve. And then you may be asking, well, I have these documents, so then we go back and say, well, who drafted them? We should look at them. And how old are they? Most people don't realize that power of attorneys, the older they are, the harder they are to use. And there are some entities that won't take them if they're over a year old. There are some entities that have their own. You need to be aware of that. You need to know who they are. But the reality is usually about every 2 to 3 years, we want you to re-sign them, even if nothing changes. Because the more current they are, tell someone, yes, they had capacity. They signed them in the lawyer's office and everything was good then. So they're probably okay now. And so it's really important to make sure that you can kind of cover all those things. There's a lot of new twists with power of attorneys, and they're very powerful documents. But if you didn't sign them in an attorney's office, you can't get a reverse mortgage using a power of attorney if one of you becomes incapacitated. So there's all kinds of little tricks and things that you have to be very aware of to make sure that you're doing all the right things. It's hugely important to pick the right people. So when you're thinking about choosing decision makers, these are your agents under your power of attorneys. You want to make sure that you're choosing the right one. We have a lot of clients that like to start with the oldest kid and kind of work their way down. But from my perspective, I don't care about hierarchy. I care about who's going to make those good decisions. And so who's going to be able to handle making hard medical decisions? Who's your best money kid? Who's the best kid with their money? If they're not good with their money, we don't want them playing with yours. And so you want to make sure that it's somebody that you can talk about your decisions with, especially when it comes to, medical issues. Here's what I want you to be able to do. Here's, if this scenario happens, this is how I want you to take care of it. And really have someone that wants to be informed. So they're doing the things that you want them to do, and do they have the right qualities and temperament and life experiences. So we don't really want to put someone that's very young in that particular role. It's not a fun place to be. And you also want to make sure that the people you put in place are very transparent. Transparency prevents lots of problems in the future. So you want to make sure that you have family members that are going to keep other family members informed, and to make sure that everybody feels part of the decisions. Hugely important. So when you think about good power of attorneys, we want to make sure they're very powerful. We want to make sure that the gifting is consistent with your estate planning goals and really your long-term care goal. Do you have the ability to hire family members or agents to provide care? The power to create maybe amending trust, and really making sure that your distribution wishes, how you want things to go when you're gone, are taken care of. So unlimited gifting is the key to long-term care planning. Hugely, hugely important. I can't stress that enough. But you want to make sure that you have somebody very good in place that's handling this kind of stuff. Because if they need to gift more than that $15,000 a year, we want to make sure that they're the right person that's going to do the appropriate gifting. They're going to make sure that nobody gets left out. They're going to make sure that they're not just gifting to themselves and none of your other children are going to get anything. You want to make sure they're honest and that they're really going to do all the right things. I'm going to talk to you really quick about Medicare, because I'm going to switch over to Medicaid, because having these the right kind of power of attorneys is going to make a difference in how you do things. Most of you may know that Medicare only cares if you get well. It is a federally paid program. You pay for that every time you get a paycheck. Does not care about long-term illness. You have to be careful about reimbursement codes, and it is, for the most part, very much a social insurance program. But with Medicaid, Medicaid is a federal state hybrid, so state laws apply. It's means tested, it's needs-based, and it's there for social protection. And Medicaid is one of the most, Medicaid pays the majority of the long-term care in this country. And so it's really important when you don't have long-term care insurance, when you haven't planned for that, when you weren't able to get long-term care insurance, depending on the circumstances, we want to make sure that you get good care, and still be able to take care of that spouse at home. There are some supported living facilities that'll take Medicaid. Not all your nursing homes will take it. And then there's some community services. And I talked to you about Medicaid because most people think, well, I don't qualify for Medicaid. And you'd be surprised how much money you really can have and qualify for Medicaid. Because there are some exempt assets. There are ways to make unexempt assets exempt and things like that. So it's hugely important for you to sit down with a good elder law attorney and say, what are my options? If I need long-term care and Medicaid, may be the payer for that, what are my options? Because I'm all about options. I think if you come in and sit down when you don't need long-term care and say, look, this is my assets, this is where they are, what kind of options am I looking at? It makes it easier to plan for down the road. When you don't plan and you're in a crisis situation, you have very limited options at that point in time, and we want you to have more. So in our trust, in our power of attorneys, we have the power to create and fund irrevocable trust, maybe to transfer real estate from the spouse or to the caregiver child, the power to transfer assets to a disabled child or disabled grandchild even, because we want to make sure that we can protect assets the best we can. But that power of attorney has to have very specific language in order for you to be able to do this. Very good, powerful power of attorneys avoid guardianship. They also can be used to file lawsuits, things like that, and really empower, clients to protect spouses. And for those of you, parents out there, maybe it's to protect the kids as well. And so you think about when you're looking at numbers for Medicaid that, these numbers look small. You can have a home, a car, and $130,380 in exempt assets, but there are other ways to make sure that there's more exempt assets out there. Healthy spouse gets to keep $3,216.50. That may not be enough. depending on what your needs are. So not being able to plan ahead and having good, powerful power of attorneys limits your ability to do things. And because Medicaid has a 5-year look back, we're always trying to get clients to come in, talk to us when you don't need care, especially when you don't need care. When you're feeling great and you're healthy, we definitely want to see you then, because then we've got lots of time to plan, And so always want to do that. Medicaid thinks that anytime you give money to someone else, you did it so you could qualify for Medicaid. And so terrible, terrible thing. They assume that there's no innocent gifting. And just because you can give $15,000 a year to each of your kids, for example, Medicaid assumes you did that just so you'll qualify for Medicaid down the road, even if that was not even a thought in your head at the time. So you always want to be very careful about what you do. And then we have people that say, hey, what if I just take care of it myself? What if I just give it to the kids? The reality is Social Security knows way more about you than you think. And they look for you to lie on that application because they can deny you and then you can't get long-term care. And depending on how you transfer, homes and things like that could cause the senior to lose, homestead exemptions over 65, things like that. And then when you outright gift to children, you always have to consider whether they're creditors, divorce, things like that, or if your children passes ahead for you. So it's really important for you guys to really think about having those documents in place and having those good documents in place. Your statutory durable power of attorney, that medical power of attorney and the documents that go with it. And then having that will or trust, whatever it is that's going to transfer your assets down the road. And so there's a lot of documents involved in planning, but those are the big ones. Those are the ones that people really look at to make sure that they're doing all the right things, to make sure that they're getting the plan works when they need it. And so I knew I only had a little bit of time. So I did this short because I would much rather spend more time answering your questions. So I'm truly hoping that you have some. I guarantee you, if you have some, someone else is probably thinking the same thing. So I don't know how y'all are doing the questions, guys. So you'll just have to let me know.
Sorry, we're just kind of people, if they want to ask in the chat or if they want to try and unmute themselves, or if they want to let me know and we'll read out a question for them. We're kind of doing it however you can get the message to us.
All right, so let's see. So in the chat,
Hi, it's Sheila. I have a question.
Sorry, Sheila.
Go ahead, Sheila.
And who has the question?
This is Kayla. I have a question.
Go ahead, Kayla.
Okay. A lot of us go online and try to look for forms and things that are readily available online, like I think it's called NOLA, some other websites that have, typical, I think even the Texas Secretary or somebody in Texas has a durable power of attorney. But can you explain, why we shouldn't try to do these ourselves? And if we were to have to, what the typical cost associated with, and I know it probably varies upon how much money in your estate and all that, but what's the typical charge of getting an estate review?
Okay, let me kind of go back and see if I can't walk back through your question. So if I understood correctly, the first question you ask is, can you use the ones online? And
right.
So the ones you're going to find online are not going to have the extra stuff that we put in ours. And if you don't have a good power of attorney and your loved one becomes incapacitated, in order for you to even be able to sign that Medicaid application, you're going to end up in guardianship court, which means that all the money is going to be very court controlled, how much you can spend, where you can spend it at. Guardianship starts off at $3,500, and you will have spent for guardianship of the person in the estate about $7,500 that first year. It's not cheap. And so it's a little easier if you have the same marriage, same kids, if you have to do guardianship. But if you've got his and her kids, things like that, it's very much more court controlled. So what you find on the internet is really not going to give you everything you need. So it's a risk. Everything you do in life, when when you take that kind of thing, you do it at your own risk. So our estate planning is all done on a flat fee, depending on what you want. I don't, as long as you're under the federal exemption amount, I'm not worried about, if you've got $1 million and someone else has $2 million, your price is the same. And so it doesn't change in that regards. And so the only time the price change depends on what you come in my office for, and depending on how much extra you need on top of that. So if you're looking to get a trust and you've got 10 deeds out there, the 10 deeds are going to cost you extra, or at least 9 of them, because that's just an extra added expense that most people don't have. So for the most part, everything we do is, like I said, on a flat fee, and it has nothing to do with how much you have. And so we look at what kind of assets that you have and where they're at to help you walk you through the different options over what's things you should consider versus, if you're doing will-based planning versus revocable trust planning to maybe an asset protection trust because you want to beat that 5-year look back period. So it's all about trying to figure out what your options are, because I've had clients that have come in that they don't need an asset protection trust. They want one, but they don't need one. And I tell them that, I'd love to, to have you do this, but you're not going to need it. And
right.
So because I don't want someone to spend money on something they don't need, if I can do something else to avoid that. And that's just me. That's just the way my office works, and we always have. Did I answer all of your questions?
Yeah, I just kind of, is it like from 3 to 5,000, 10,000? I mean, what's it? Can you give like a ballpark figure?
Will packages start off at $750 in my office, as long as you have adult children, and you could spend up to 12 to 13,000, depending on what all you want. But it's usually more than one thing.
I got you. Okay, one other quick question. Like, for instance, my parents, they're not in any debt. They have a pretty good amount of savings. The only thing that they really have of any value is their house. So I read somewhere recently, I mean, in their will, they say directly that the house goes to the children, period, split 3 ways. There's 3 of us, that's it. Okay, but I read somewhere that if you have real estate, you must go through probate. Is that true?
No. You will go through probate if you haven't planned accordingly. So you can do things like, if all your parents have is a house and they don't have a lot of other assets, then what we're going to do for you is do that will-based planning for your parents, but we're going to do a life estate deed. What a life estate deed is, it says the house is ours. I'm talking about your parents, all right? I'm your parent. House is ours. Each of us have an undivided 50% interest in this house. When one of us passes, the survivor has 100% of the life estate, which means they can do anything they want to with that house. They can sell it, they can gift it, but if the surviving spouse owns that house at their death, it would go to you 3 kids. All you would be required to do is we file what we call an affidavit of death. And that terminates your parents for each parent, that terminates your parents' life estate, and the house belongs to you kids. And then y'all get to fight over which realtor you're going to use. It's really super easy, for the most part, as long as you're all on the same page, it works really well. But if you're single and you own real estate, I always want you to do the life estate deed, because we're looking to avoid probate. And don't get me wrong, probate is very easy in Texas. It just takes a while. It's a 6
And you have to have a lawyer, right?
Yes, they kind of require that because you're transferring real estate and things like that. So it's really court controlled. I've only seen a few instances where the court lets someone do something, but I even had a client call me and say she made it all the way to the hearing. The judge realized that she was pro se. It's somebody without an attorney, and he stopped the hearing and told her to go get a lawyer. You could end up in that far, but probate runs about $3,000 to $3,500 in Texas right now. And so
versus the price of getting a life estate deed would be
a lot
like
cheaper. Yeah, a lot cheaper. Now, other states, depending on where, if your parents moved to a different state to be next to for a sibling or something like that, I think Arkansas or Kansas is one of them that the attorneys get paid based on how much is in the probate estate. Right. You're like, from an attorney's perspective, I'm jealous. But
we're all in Texas, so that doesn't apply.
But yeah, the life estate deed is fantastic. We always encourage clients, especially if they're single. You know, if you've got long-term care insurance or you've got plenty of assets and in your family's like, look, we're not qualifying for Medicaid. We want to stay wherever we want to stay. We don't want that to be an issue. Then you can leave the house in the revocable living trust, no problem. You know, so it just depends on your circumstances. So we sit down and look at the entire financial picture of our clients so we can determine what's the best way to proceed. And I'll give you my best option, and then I'll give you some, you know, pros and cons of anything else you want to do, because that gives you the ability to make your own decisions.
Okay, thank you, Kim. And one other final question. Do y'all happen to do like video appointments?
Well, we do them by Zoom. And so you can do your
Okay.
signing by Zoom, but you can do your initial appointment by Zoom. You can do your design meeting by Zoom. Any questions you have, you can do them by Zoom, but your signing has to be in the office.
Okay. Thank you.
Not a problem. Thanks, Valerie. So, okay. So anybody else have any questions? I'm not seeing the
chat.
I'm going to stop the share. I can see the chat. I can't see the, I can't see if it's a Q&A. So that's why I went ahead and stopped it. And so any other questions that y'all have? Don't be bashful. I'm like, I'll be the easiest person you'll talk to probably today. And so, and I happen to like Zoom because I can put on this nice, pretty shirt and then you can't see the jeans I'm wearing. So, and it makes for dressing to work a little easier. Is there an estimate to review an existing Texas lawyer prepared will and make suggestions? Yes. You call in my office, you just call the office and schedule an appointment. I want to see those documents ahead of time, so I have time to review them. I can do most of it in a consultation, but I prefer not to. So anything that we can get, you know, ahead of time to look at, and really you look for key things that you're looking for when you're reviewing documents. And so if they're more than 2 to 3 years old, your power of attorneys, I'm going to tell you to redo them anyway, regardless, because we don't like ours to be over 3 years old. I have a lot of times where as our clients age, I see them more often. So you start to hit those, you know, 70s and 80s, especially around the 80s. I want to see you every couple of years or even every year. I just want you to come in and have coffee with me. Just come in and sit down and chit chat for a little while. We look for things like elder abuse because elder abuse is on the rise. So we look for capacity, we look for elder abuse, and something simple as I had a client came in and spoke, you know, came in for her review and asked her what was going on, how things were going, what's new, still living by yourself. Oh, no, grandson moved in, you know, so long story short, she's paying grandson to basically live with her and not do much of anything else. So he's exploiting her, you know, so we want to make sure that those kind of things don't happen to our clients. So we try to see them as often as possible, you know, just because it makes us feel better. And then some of our clients, their kids don't live here. And so they don't get to see them as often, you know, so if they can pop in, I keep some really nice chocolate on the counter that a lot of my clients just come in for that. And so, but it just gives us a chance to kind of touch base, check on them, make sure they're okay. And because it helps as you age to have the more current documents so no one can say that you didn't have capacity.
Kim, I have a question.
Sure.
So other than what you just said, why would you need to redo your power of attorney every few years?
Well, in Texas, except for, you know, right now during COVID, for the past 6 years prior to COVID, our legislators have updated the power of attorneys every 2 years.
Oh,
So
wow.
every 2 years, they've made changes.
I did not know that.
So you want to have the latest and greatest, but even if I don't make any changes to yours, just because they're now 2 years old versus 4 or 5 years old, makes it easier for your agents to use. And so the older they are, the harder they are to use. And so, and if you're in a crisis situation, you want to make sure you can use what you have.
Absolutely.
We did, you know, we've done Medicaid planning. We did Medicaid planning last year. It was 2019 probably, because we didn't do a lot of Medicaid planning last year. In 2019, we had almost 2 back-to-back Medicaid cases where we were doing Medicaid crisis planning for them to go in the nursing home. One of them was 39 and the other one was 40.
Oh,
I mean, you don't know, and so it's one of those things where you just never know. Things happen. And so, the goal is to get those documents in place so that if those things do occur, it's a lot less painful and a lot less expensive, down the road to get things taken care of. And the goal is to make it easy. So you put your documents in place, and then pretty much everything after that is kind of easy. Update every now and then. And so, and usually you don't have any problems. And so,
Kayla just asked if it's necessary to record a power of attorney with the county clerk for it to be valid.
You don't have to record it unless you're signing a deed. And then we have to record it. And so if you're signing as a power of attorney, have you record it? I only like to record when I know I can't get a new one. Like somebody doesn't have the capacity, we try to avoid that, because if I record a power of attorney and you still have capacity, then I have to revoke that power of attorney and then record the new one, or at least revoke it in the county records if you do a new one. It's an added expense that's not really necessary as long as you have things taken care of. And so before you pass on, there's, I think it's Valan. I'm sorry if I pronounced your name wrong. She asked about setting up a power of attorney after someone has dementia and is nonverbal. They have to have capacity. We've had clients that could only sign with an X, but they had capacity. So maybe it's a physical disability, things like that. When you reach the point to where you don't have capacity, you can't do power of attorneys anymore. And if it's close, depending on your family dynamics, I'm going to make you get a letter from the doctor that says they do have capacity before I let you sign, so because I don't want to be caught in that war between the kids over they had capacity or didn't have capacity. Even clients that I thought had capacity, because I knew their kids, based on what they told me, were going to be a problem, I went and had them do it anyway. I went and had them go see the doctor, have the doctor put in their medical records, or they had capacity to sign legal documents, and bring me something that said the same thing, because that protects the client. And so it was a little more frustrating to have to go do that, but it helps them and the kids that they wanted to be on as their agents. It protected them as well. So there's a lot of things that we do to kind of, maybe get you where you need to be. And some things are a little direct and some things are maybe a little indirect, but we try really hard to take care of stuff. I don't have an office in the Cypress area. And so what we do lately, because I've got clients all over Texas now, and it's like the Zoom has been fantastic. So a lot of times the clients will come in, we'll take care of all their stuff. I will send your documents to an attorney's office close to you, and you will go in there and sign. They will execute the signing with one of my staff on the phone, make sure there's not any problems. They send the documents back to us. We make all our copies, scan everything, put it in your binder, and send it back to you. So I have clients all over Texas. The furthest one right now is El Paso. I have a client in El Paso. But I have them in, I have one now in Harlingen. Maybe it's El Paso is still farther away. So I have one in Harlingen, El Paso, San Antonio, Bryan. They're just, it's very easy for us to do because of Zoom, so, and then we've tried to make sure we could take care of, the clients that have been referred in. A lot of those were referred in. So we do what we can to help make sure we can take care of them. Andrea asked that some banks are not accepting some fiduciary documents, especially if they're very old, and you're absolutely correct. If you're even remotely worried about whether or not your bank will take the power of attorney, you give them a copy now and say, is this a document? Because they have to send it to their legal department, and they're never in Texas. So they have to send it to their legal department. They have to figure out Texas law to see whether or not it's something they can take. And it's not something that's, looks pretty similar to what they need. And it takes about a week to get some of that stuff back or longer. And with COVID, it's taken even longer. So the goal is, if you're worried about it, absolutely put some things in place and have it checked, because it never hurts. If you have investment accounts at Morgan Stanley, Ameriprise, Merrill Lynch, they have the big ones have their own power of attorneys for those accounts. you must sign theirs. They will not take Texas power of attorneys, and it costs too much to litigate that issue. So we always look and see where the client's money's at to say, hey, you need to go back and get a power of attorney from this place. And so because we want to make sure that your agents can access everything they need, which is why we get all that information from clients.
That's good information, Kim. I didn't know that.
Always ask. And so, and make sure for you guys, here's something really important. Make sure for you guys that have had bank accounts that have been around for a long time. I have to tell people, I've been at Wells Fargo forever because it's just too hard to leave. But I was a First Interstate before Wells Fargo bought them out. I was with them. I've been with this bank for a very long time. Until I set my trust up, I didn't have beneficiary designations on my bank account. If you have a bank account that you've had for a long time and you're not doing trust planning in my office, you probably don't have beneficiary designations on those accounts. We tell every client that comes in that does will-based planning, please go to the bank and put beneficiary designations on those accounts because we don't want you to probate for a bank account. And so you check your beneficiary designations, now, because I'm telling you, please go do it now if you haven't done it. You should check your beneficiary designations after you lose someone passes away. You want to revisit every one of those beneficiary designations again. And think about doing primary and contingent. So just in case somebody passes and you don't have capacity anymore, you get that primary beneficiary, that contingent beneficiary. So you're covered all the way around. And then make sure, I don't know if any of y'all are teachers and have teacher retirement, but you must do your beneficiary designations. They must be in Austin. They can't be anywhere else or they're not valid. So if you did beneficiary designations at the hospital and they never made it to Austin, they're not valid. So you have to be very careful about making sure that you do all the right things. They're all accepted and you've got documents proving that you sent it in and here's my confirmation, and you just put it all together with your estate planning documents, and man, your kids are gonna love you. And kids that have parents that plan really well are just the happiest kids ever. And then I've seen those kids that the parents didn't plan at all and they're in my office crying because they don't understand why their parents hated them and left them this mess. And so, so definitely do something, whether it's me or someone else. I highly encourage you to definitely, visit and get everything done correctly. It will definitely give you that peace of mind that you wouldn't have otherwise. Let's see. Kayla asked, I've been told that once a single person passes, any credit card debt, excluding mortgage and car, does not have to be paid back. Is that true? It makes it more difficult to pay creditors or for creditors to get paid if you're not in probate. Creditors get paid in probate. So if you're not probating, the creditor may not get paid. Now, having said that, if you sign that application for that credit card, you're on the hook. If your spouse got that credit card and added you as a signer, you're not responsible for that debt. And so it's definitely depends on, I have had clients in ICU that have been served over credit card debt. It was shocking. And, but once you pass away, it's a whole lot harder. And it's a whole lot harder for the creditors to get you. So if there's no estate, we just tell you to send them a letter telling them that there's no estate, and they're just going to have to write it off. Yeah, Andrea, I'm so sorry. And she said she spent 6 years in probate because there was no planning. I have a probate case that we've had open in Brazoria County for 8 years now because the attorney drafted a joint will. You don't do those. It was just horrible. So all of it was very badly done. And so it took a long time to get that settled, get the property sold. I mean, it was just horrible, so definitely make sure that you get some good things in place. And so anything else? All right, kids. Well, I enjoyed this. So, don't hesitate. Oh, on your paperwork, Kim was the bomb. Okay. Right. Just write that down. She was amazing. She did all the right things because I want Catherine and I wanted to let me come back, talk about maybe something else. So be sure to tell them it was great. And so, And
We are
definitely.
always happy to have you back, Kim, always.
All right, guys, if you need anything else, let me know, and I will talk to y'all later.
Bye, thanks.
Bye-bye.